This is Lisa Ireland with the Blue Book Network. The Cromeens Law Firm and the Blue Book Network are here for the construction community in both the good and the bad times. We know that the coronavirus crisis has been so difficult on everyone, and many businesses are asking, gosh, what should we do next? So today we have put together a short Q&A of the most common questions that we are receiving from our clients on how to manage their businesses during this time and their workforce. We will come through this pandemic and we will be stronger than ever. So today, to answer all of our questions, Joseph Munoz with the Cromeens Law Firm is going to be our legal expert, and he's going to take us through the top 10 questions that we have been getting. Joseph?
Hi, just a little bit about myself. I'm from San Antonio. I attended Texas A&M University at Corpus Christi for my undergraduate degree. I also received my master's in business administration there. And after that, I attended St. Mary's University, where I got my law degree. I've been practicing since 2008, and I have been with the Cromeens Law Firm for about a year now, and just want to thank you for this opportunity, Lisa.
It is a pleasure. So with that, let me get started with our questions. The number one question we're getting is, what should an employer do if they have an employee who just doesn't feel comfortable returning to work?
Well, obviously, employers should take reasonable steps to make sure that their employees do feel comfortable. Employers can refer to the mayor or the governor's guidelines. They can also refer to health organizations like the CDC, and they want to take a look at what's being offered in PPE in respect to that. You can do hand washing stations. You can require facial masks. Require social distancing. Some of those steps can go a long way in making your employees feel comfortable at work.
The second question that we're getting is, what do they do if they have an employee who wants to stay on unemployment over returning to work just because of the extra stipend?
Yeah, that is an issue these days. A lot of people on unemployment are making more now than they were when they were working. And of course, employers cannot force employees to go back to work, but what they can do is put the offer to return to work in writing. You want to include, the basic information, the rate of pay, the schedule, but also what you want to include is the guidelines that you've referred to or referenced from the CDC or the government. And you want to communicate to the employee the steps that you have also implemented. That way they'll feel more comfortable returning to work. Now, if the employee still does not want to return to work, you can talk to the Texas Workforce Commission and file a complaint. The TWC will take this as a case-by-case basis. They're not in any hurry to cut off any benefits during this difficult time. And there are some protected groups that do not have to return to work. Some examples of these would be if you're 65 or over, if you live with someone who's 65 or over, or there's some type of quarantine going on in the household. Now, these specific examples, they would not have to return to work even if the employer provided a safe working environment. But again, it's a case-by-case basis.
So how should they handle an employee that is returning to work after testing COVID-19 positive and is recovering?
Well, if an employee was diagnosed with COVID-19 and they're still recovering, they should not return to work at that point. From what I've read from the CDC and other health organizations, is there's a two-prong test for employees who have been diagnosed with COVID. The first prong being they should not return to work unless their symptoms have subsided for at least 3 days. Symptoms being just examples, coughing, shortness of breath, and fever. And those should all subside without the aid of medication. Now, the second prong would be they should wait 7 to 10 days from either the initial diagnosis. That gives them a little leeway and ensures, well, doesn't ensure, but it does what they require to make sure when they come back to work that they're not contagious and still have a safe working environment.
So how should they be documenting their PPE measures to protect their business from future liability?
What I would suggest is publishing a company-wide memo, communicating all the steps that the employer has taken to ensure a safer working environment. Some of those examples I already spoke about, social distancing, facial masks, hand washing stations. You want to make sure you put that in writing, and you also want to make sure that the employee signs that document before returning to work, very much like an employee handbook. If you don't have an employee handbook, that's something you should do as well.
Because of the lack of PPE available right now, just due to the coronavirus being out there, and a company is unable to get PPE for all of their employees, does keeping their team on site without PPE violate any obligations to maintain a safe and working environment?
Well, that would depend on the work environment itself, but in general, construction work is considered a low risk environment. So there's not a lot of required PPE, but I again encourage, the social distancing and the face mask, but it really depends on where the work site is. Obviously, if you're working in an environment like a hospital where you're more susceptible, then the required PPE would be a little more strict. But in general, you could offer masks. If you can't afford or can't find masks, employees can use handmade masks or bandanas, anything that offers some sort of protection.
What evidence or documentation do they need to gather to support any claims for an excusable delay or force majeure event?
Well, force majeure clauses are created out of contract. So you would have to look at the actual contract and the terms of the force majeure clause itself. A lot of them give specific examples of situations that qualify, and courts tend to look at those examples, and anything reasonably related to that would qualify, and some have some catch-all phrases. So what you want to document for those would be anything and everything related. If you can't find the necessary resources to get the job done, then you need to document that. If you can't find sufficient labor, document that. If the work site itself has been closed, there's usually a notice. Make sure you keep those notices. Anything that you think might be helpful to show that you were not able to perform would be useful.
Can they recover for the impact of inefficiency causing further delays once the site reopens? And can they recover the costs associated with business interruption, a scheduler time impacts, even perhaps like their on-time bonuses and their milestone dates resulting from project delays?
That would depend on the wording and the terminology used in the bonus clauses. Generally, I would say no, because those are usually pretty specific. But with all the work stoppages and delays, what I would suggest is for these subcontractors to contact the party that they contracted with and see if they could reestablish some new bonus programs or new timelines. A lot of these GCs and owners are going to be really motivated to get things done quickly, and that might help their cause.
So how should a company handle the general contractor, the owner, or even the sub that has been robbing Peter to pay Paul? If the revenue stream for some projects are cut off due to pandemic-related shutdowns, and the GC or the owner is having difficulty paying its subs, what can be done to protect this company?
What I suggest to protect yourself is to utilize your lien rights. Mechanic liens can be very effective in difficult times like these, but it's extremely important for you to know that the notices themselves, they have to have the proper language and they have to be sent out timely. Now, if you miss the deadline even by a day, you could lose out on all of your lien rights. But that is the best way to you can't really ensure payment, but to protect yourself, because you attach the lien to the property itself, meaning you could sue the property owner Now, when they get these lawsuits, they're pretty motivated to get their GC or contractors to pay up.
Should they be asking for financial checks and references mid-job due to the changing economy that we're working through right now?
I would suggest doing anything reasonable to protect yourself. You should always do your due diligence in deciding who you work with or for. I would suggest asking for references, but don't just ask for them. Follow up. Ask relevant questions. See how long these people have been in business. You really need to do your due diligence during these difficult times.
So my final question, Joseph, question number 10. Now that the stay-at-home orders are being lifted, does a company still have to pay out sick leave or FMLA that was defined in the Families First Coronavirus Response Act?
Well, that would depend on the underlying reason for the leave of absence. If the employee was on leave to care for their children because there was no other facilities open, then once those facilities did open, then the employer could possibly stop benefits. Now, if the reason for the leave was for medical reasons because they were diagnosed with COVID, or someone in the household was diagnosed with COVID, then the lifting of the stay-at-home orders would not affect that. So again, it's a case-by-case basis. You've heard me say that a lot, and you've heard a lot of answers saying it depends. That is why our firm wanted to offer a free 1-hour consultation where Blue Book members could email us their questions ahead of time. I can review them, set up a call where I can address their concerns, hopefully offer some guidance without any attorney fees attached.
Well, Joseph, that is really an amazing offer. We appreciate the fact that you want to help not only the construction community, but our Blue Book members that are so close to us. So thank you for your time. I know that you don't have all the simple answers without looking into the details, but thanks for taking the time and answering our top 10 questions today that are COVID related that affect our companies and our workforces.
Absolutely. It was a pleasure. Thank you.